Hello, everybody. Welcome to the virtual Amicus, and I'm Jay Lodha. Well, back in the 90s, the legal profession was completely dominated. It was a male-dominated profession, but things have changed now, if not significantly, but then slightly and slowly, gradually things are getting better. You see a lot of these young elected and appointed members of and heads of states and governments as well. A lot of women in the legal profession as well have successfully managed to break the glass ceiling in the legal profession. So today we have with us Miss Prabuddha Sharma. She's a young, upcoming, dynamic advocate practicing before Honorable Rajasthan High Court, majorly before Jaipur bench. And just to give you a brief background about Miss Prabuddha, she has been practicing since 2013. Her practice areas extend to a multiple areas of law, and she has also had the benefit of handling matrimonial litigations and associated criminal and civil litigation at family court, High Court, and before Honorable Supreme Court as well. So she would be sharing a brief outline of matrimonial litigation in India, emphasizing importance of mediation process and sharing personal experiences to streamline the process of quick and effective results. Over to you, Ms. Prabuddha.
Thank you, Jay. Matrimonial litigation in India has a bit of reputation on account of multiple factors, on account of institutional roadblocks. We expect the process to be as quick and efficient as that in the West, without taking into consideration the cultural background, the docket explosion in India. So today, this is just an informal discussion, just an outline of matrimonial litigation to make everyone who is either conducting the proceedings, who is instituting proceedings, or somebody who is participating in the proceedings to understand what lies before you and how to handle it. I will have be sharing a couple of slides so that the process is much easier to understand. Matrimonial litigation, specifically in India, lies in these three categories. That is, it is either on account of requirement to separate from the spouse. It also subsequently involves requirement of maintenance and custody of children along with visitation rights. Now, when I speak of matrimonial litigation, my emphasis would be to share my experience. Categorically, working in Rajasthan first, and that too at Jaipur, because in the last 4 to 5 years, I've had the benefit of handling this litigation extensively, seeing proceedings from inception to conclusion. And what I shared further, I make an attempt to share tiny tips and anecdotes to give you an idea as to what lies in front of you and how mentally prepared you should be when you enter into this litigation. Now, when we speak of separation, separation includes divorce, judicial separation, and separation by virtue of institution of suits. Divorce is something which is known to a lot of people by virtue of so much of information available on internet. It is also one of the preferred modes of parting ways with your spouse as compared to judicial separation and as compared to suit. Suits are quite limited. They are instituted on only a few available grounds, such as in instances of void and voidable marriage. That is where marriage has taken place on account of the fact that party did not give a valid consent, or that parties were not of the proper and legal age at the time of marriage. So the scope of suits is quite limited. Judicial separation, in my opinion, is something which is going to lose its impact or usage completely in the next few years. It is just an order in which parties live separately. It does not end the marriage, and effectively is something which is not used much. The most prevalent mode of parting ways between spouses is by divorce. In divorce, there are two main categories. One is divorce by mutual consent, which has gained a lot of popularity of late, and rightly so because it is very quick, it is quite cost efficient, and it involves minimum litigation. I will be discussing further as to how the scope of mutual consent has been expanded by the courts, how the process has been streamlined, and how the process has been made very, very quick and efficient by virtue of certain judgments and indulgences granted by the courts. Then comes the contested divorce. Contested divorce is the one that is dreaded by most of the spouses. It is in fact that part of litigation, of matrimonial litigation, gains that gives it that kind of ick factor that people don't want to participate in as smoothly as they would in the other litigation. So when I speak of mutual consent divorce, divorce by mutual consent is enshrined, the concept is in 13B of the Hindu Marriage Act. Uh, earlier, when when this was not very popular, like other grounds for other grounds of divorce requirement, there was a requirement of 1 year of marriage. The same subsists even now. So if you're somebody who wants to take a divorce, even after expiry of, let's say, a few 3 to 4 months of your marriage, you can't resort to mutual consent also. You have to wait for 1 year of marriage to have elapsed. However, earlier, when a party would file an application, parties would file application to seek divorce by mutual consent, there was a mandatory 6 months cooling off period. Now, by virtue of recent decisions of the apex court, as well as earlier even the high courts were doing it, this requirement of 6 months to wait after filing an application to obtain divorce by mutual consent is dispensed with. So the process is very simple. You file a joint application, after which, after expiry of one or around 1 week or 10 days, you move another application to waive the mandatory 6 months period, and accordingly, within a span of, let's say, 1 month to 2 months maximum, you are able to obtain divorce by mutual consent. The benefit is that there is no specific reason that needs to be mentioned by seeking divorce by mutual consent, as compared to in contested divorce, where there has to be reasons such as infliction of cruelty, desertion, and other grounds. This is very efficient, it's very quick. The underlying principle is that parties, if they do not wish to live together, they should not be forced to undergo the entire process and deteriorate the relationship further. Now, I will be discussing mutual consent again when I discuss about maintenance. Contested divorce is a divorce instituted by either of the spouses on any of the reasons given under Section 13(1) of the Hindu Marriage Act. However, the most used ground, and the ground that inevitably finds its way into the pleadings, is cruelty. I will be discussing cruelty subsequently. Before I go into the grounds, what is necessary to understand from the point of view of advocates as well as from the point of view of litigants is that the pleadings in a contested divorce, contrary to the common opinion that parties are free to write about their grievances and it's a very informal process, it's actually not like that. Pleadings have to be very specific. If you are harping on a particular ground, that ground has to find a way into the pleadings. You cannot have a ground of cruelty written vaguely in the title, the subject matter, and not have pleadings in support of that. For the very simple reason that if your pleading is incomplete, if your pleading is inconsistent, if your pleading is general, vague, when you make sweeping allegations, even if you are able to obtain divorce at family court stage, inevitably the litigation travels to high court where things get so difficult. And once you omit to include something in the pleadings at family court stage, you will not be able to do so despite there being a statutory provision before the high court, for the very simple reason that because there is a docket explosion and court does not have time to go into these things. So please, when you institute a contested divorce, seek legal counsel. Even though you might have a lot of feelings towards your spouse, even though you might feel the need to vent, please have concise, precise, to the point, succinct, and legal pleadings. General vague allegations, sweeping remarks are not required in contested divorce. Now, as I discussed, cruelty inevitably finds its way into every divorce application that comes up. Every other ground that is given in section 13 can be included in cruelty. So this is something that needs to be understood very clearly by litigants as well as advocates, that though there are judgments that say that a party is not required to enumerate each and every incident of cruelty, however, a party is required to specify at least some instances of cruelty. Here I'll pause, and also I'm not touching the aspect of criminal proceedings with respect to matrimonial litigation. However, whenever this ground is invoked in divorce petitions, more often than not, the party has already resorted to registration of FIR, criminal complaints, maintenance proceedings in Domestic Violence Act, 125 CRPC. So please make it a point that when you draft your petition or your applications, your pleadings are consistent. You cannot take X ground in your domestic violence and take up a Y ground only in your petition of divorce for divorce. The pleadings have to be consistent. Otherwise, even if you have a genuine case, it will not work out for you. Cruelty, very broadly speaking, is of physical and of mental emotional nature. Within its definition, it includes these aspects. Mental emotional cruelty would now also include financial. To explain, physical cruelty, as is very clear, is infliction of bodily injuries, whereas mental, emotional, and financial cruelty has a very wide definition. It would include instances of not providing access of consortium to conjugal rights to your spouse. It would include instances of insulting your spouse by verbal, providing financial assistance to your spouse, and not permitting your spouse to become financially independent. A lot of women recently, because on account of marriage, they have to let go of their career and subsequent assistance on account of multiple reasons the dispute arise, and that is where financial cruelty comes into picture. Irretrievable breakdown of marriage is defined as another ground. It's for seeking divorce. It's defined. It's used in instances where the marriage has broken beyond repair. Now, every party who initiates litigation of divorce feels that the marriage has broken down beyond repair and they should be granted divorce quickly. I say it with utmost respect to the feelings of the parties. However, irretrievable breakdown of marriage is in a completely different sense. It is that even if attempts are made for resolution of disputes by virtue of mediation or by any other professional counseling, any other mechanisms possible, by virtue of the nature of the relationship between the parties. It can be on account of nature of allegations, nature of pleadings, long duration of separation, that forcing the parties to live together by refusal to grant a degree of divorce would itself tantamount to injustice. I'll give an example. Most of the matrimonial instances where divorce is initiated by the wife, in criminal proceedings, allegations are made against the family members of the husband. Allegations are sometimes pertaining to commission of sexual offenses. At the same point of time, in the divorce proceedings, wife would inevitably make even if she initiates divorce, if the question is put to her in the court that would you like to cohabit with the husband if he's willing to A, B, and C, abide by A, B, and C condition, she would say the court will see through it outrightly because the nature of allegations is such that even if she's saying it that she would like to live together, it is not. It is evident that it will not work out. In those instances, the court is left with no other option but to grant divorce so that the parties can part their ways and live a peaceful life. It also happens in instances where at the family court stage, divorce is filed on the ground of cruelty. If the divorce is refused and there is an appeal, and at the appellate stage, either the party has started living with somebody else, or that by virtue of time, it's been more than 7 years, 10 years, they have been living separately, they've been living independent life, that there is no purpose left to make them by refusal to grant degree of divorce. And therefore, this irritual breakdown of marriage theory comes into picture. Even if you have not filed a divorce on this ground, by virtue of these two factors, that is nature of allegations and long duration of separation, the court will grant a divorce on this ground. Maintenance in matrimonial proceedings, it's the core of litigation. If this it gets addressed at the very beginning, then there is every possibilities that the parties will file a divorce on ground of mutual consent. Now for maintenance, before going into the factors of what are the relevant grounds and how does the court proceed, I'll discuss two aspects. First, there has been a watershed moment in 2020 by virtue of a judgment of the Apex Court. I'll be discussing it subsequently. Earlier, maintenance was granted on account of guesswork. Parties ordinarily don't disclose their source of income. So there are instances in which maintenance has been awarded to spouse, specifically wife, on account of her filing photographs of husband standing next to expensive cars, sitting in an expensive office. The court takes a presumption that because he's traveling frequently, because he has expensive cars, therefore he has high status in society, and therefore the wife is entitled to a handsome sum of maintenance. There was no obligation on parties to file an affidavit to disclose their assets. Maintenance part of the litigation is something that leads to multiplicity of proceedings because inevitably at the stage of interim maintenance and at the stage of final maintenance, the matter will travel to an appellate authority. And therefore, subsequently, the Honorable Apex Court felt the need to streamline the process, lay down some guidelines, which I'll be discussing in the next few slides. So maintenance is granted, can be claimed by the spouse, includes both husband and wife. Contrary to public opinion, even husband can claim maintenance, and by children. As regards the parents-in-law and the parents, there are other provisions. I will not be addressing the same here. Now, to spouse, the maintenance was granted on the basis of standard of living, on the basis of the education. A highly qualified person, doctor, lawyers, engineers, those in government jobs with a fixed income. The maintenance is calculated based on the pay scale that they receive, along with the fact that if a wife is somebody who has a degree, who is capable of earning herself, but has chosen not to work voluntarily, not on account of the fact of marriage, but has forsaken her career without any specific reason, that aspect will also be considered while calculating the quantum of maintenance. With children, the maintenance is quite dynamic because the amount of maintenance required by a child who's aged 2.5 years will be different as compared to a teenager of 12 to 14 years by virtue of education and other allied expenses. Now, like I said, maintenance can be demanded by wife under Hindu Adoption and Maintenance Act, under Section 125 CRPC, under Hindu Marriage Act, under Domestic Violence Act. All these proceedings can be instituted simultaneously. However, husband will be required to pay maintenance only one consolidated sum, not under each and every heading. Now, husband can also claim maintenance. However, it's only under the Hindu Marriage Act and not under Hindu Adoption and Maintenance Act or under Section 125 CRPC. Children are entitled to maintenance by the age of majority. With female child, there is a dichotomy of view. There are courts that are of the considered view that a female unmarried daughter is entitled to maintenance from her father. However, subsequently, this doctrine has developed that a female daughter who has crossed majority, excuse me, and is able to maintain herself by virtue of her education, then that daughter is not entitled to maintenance from the father. The underlying principle is that nobody should be allowed to profit from the other person on account of maintenance. Now, like I said, that proceedings under Domestic Violence Act 125 CRPC and all can be instituted by wife. However, maintenance is paid only under one heading. Now, I briefly discuss the judgment of Rajneesh versus Neha. Because there was a lot of guesswork involved in granting maintenance, because there was a docket explosion only on account of maintenance matters, leaving aside custody, visitation, and divorce petitions, because maintenance forms the core of matrimonial litigation, this judgment has laid down certain guidelines. Most important, which I feel, is filing of affidavit of disclosure of assets and liabilities. Every party to a litigation in matrimonial matters, in divorce matters, specifically in maintenance matters, to be more precise. A party who is claiming maintenance, along with the application, has to file an affidavit of disclosure of assets and liabilities. Party who is required to be paid, who's made an opponent in that matter, is also required to file a reply, along with an affidavit of disclosure of assets and liabilities. Time given is around 4 weeks, not more than 2 chances are given. What happens in the instances if you don't file it? If you don't file it, even when it is required by law to do so, an adverse presumption is drawn against you. Pleadings made mostly by the wife, because maintenance fee mostly by the wife, are deemed to be true, and maintenance is awarded accordingly. What is important, another aspect of this judgment that's important, is that it applies to even pending proceedings. So even in proceedings in which maintenance has already been awarded, or in which maintenance, interim maintenance or final maintenance has to be determined, parties can accordingly move application that I would like to file an affidavit of assets and liabilities in view of judgment of the Honorable Apex Court. I would also seek for the directions that the opponent may also be directed. This has done away with the guesswork. Now, often, because these proceedings are long, so what happens is sometimes a person is in the job while matrimonial litigation is going on, and sometimes while the proceedings are still pending, they might retire. Or you might be a person who is gainfully employed during litigation, but like, for example, on account of COVID outbreak, there are so many people who have suffered huge loss in business. The business has closed down, or they have lost their jobs. So in those circumstances also, if there is an X amount of maintenance that is ordered by the court to be paid by you, you can again file a supplementary affidavit if you have already filed an affidavit, or an amended affidavit, or simply an affidavit saying that on account of XYZ reasons, I have suffered loss of income, or I have suffered, my income has completely gone, I am unemployed. And these factors may kindly be taken into consideration for redetermination of maintenance amount. Therefore, I say that this is a watershed moment in matrimonial litigation, because it is going to streamline the process beautifully, and it is going to take out, and once the guesswork gets out of the picture, even if you try to file an appeal, because the order of maintenance will now be based on completely cogent reasons, therefore, even the appeal will get decided much quicker. There is an exception, obviously, for those of unorganized sector, below poverty line people, economically weaker sections. They're not required to file these affidavits. However, a free hand has been given in these cases to the concerned court to come up with ways to determine the income of the parties. I'll also add that earlier under 125 CRPC, applications for maintenance, interim maintenance more specifically, were to be decided within a period of 60 days. However, here that the entire proceedings will take place between 4 to 6 months. At this point, I'll also pause and add that one of the grievances of parties who participate in matrimonial litigation is that they are lengthy, that on account of factors beyond their control, the litigation goes on into several years. There is an option, there is a remedy available. You can file a writ petition before the concerned High Court seeking speedy disposal of matrimonial litigation. So let's say if there has been significant development in your matter, however, it is now stuck at a fixed stage, or alternatively, despite there being elapse of a long time, the matter has not progressed. Along with the order sheet, you can file a writ petition and the court will direct within preferably from time to 3 to 6 months to dispose of the matrimonial litigation divorce petition. So this is another mechanism that parties can avail in the event they feel that the litigation has been pending for quite some time. Like I said, if the husband does not disclose the exact amount of income, and adverse inference can be drawn against him by the court. I've used the word husband uh, more often than not because it's a tendency in a party who is bound to pay to conceal the income, and a party who is claiming maintenance to exaggerate the claim amount. So therefore, if the husband does not disclose his assets and liabilities or his income by filing affidavit, like I said earlier, the court will take an adverse presumption and will treat and will grant maintenance solely on the basis of the pleadings by the wife. As regards execution of maintenance orders, though a provision has been made in the judgment, the guideline specifies that it is to be executed at decree of the court. That process is roadblocked by infrastructural problems simply on account of docket explosion. So there, I feel that there is a lot of scope of improvement, and execution part of maintenance, the litigation, the litigation, the infrastructure has to develop phenomenally to streamline the process. Custody and visitation, the third and the most complex part of matrimonial litigation. The underlying principle in custody and visitation litigation is welfare of the child. That is the only principle that is fixed in these matters. Nothing is fixed. Everything is dynamic. It depends upon the conduct of the parties. It depends on the wish of the child. Ordinarily, as everyone is aware, for an infant, for a minor below the age of 5, custody is with the mother. There have been instances in which the court has taken an exception on account of factors such as inability of the mother to take care of the child, either on account of financial condition or on account of a personal behavior. However, the custody of a minor remains with the mother only, more often than not. Custody can be granted, it can be sole custody to one parent, it can be joint custody to both the parents, and it can be to a third person, that is grandparent or somebody else, in the event the court finds that neither of the parent is fit to raise the child. The third option is not resorted more frequently because, like I said, the underlying principle is welfare of the child, and it is believed that the child will benefit the most if he gets the love and affection of both the parties. Custody is different and visitation is different. Even if one party gets the sole custody, in no circumstance will the other party be denied of visitation unless the other party is considered as a threat to the child. So, for example, there is a petition which is pending for final custody. Interim custody is with the mother. If the father is posted outside the territorial limits of where the mother is residing, in those instances, visitation, father will have the rights to visitation. Visitation can be at the court premises in the event the relationship between the parties is so bad that they cannot meet at any other place. Specifically in times of COVID, where physical visitation is neither advised nor is possible, the courts have come up with a theory of video have been given the rights of visitation, however, are unable to exercise the same, can move appropriate applications before the family court, before the high court, before the honorable apex court, that electronic access be granted to them. When I discuss electronic access, I would like to point out that because litigation, matrimonial litigation is driven by ego, there is a tendency between the spouses to use the child as a pawn. And this conduct is recorded very strictly by the courts. So, for example, in electronic access, if there is a fixed time in a week where you're supposed to permit your child to have a video conferencing with the father or with the mother, if you keep disrupting the proceedings, making excuses of internet, shutting down the computer, withdrawing your child from the video conferencing, disrupting it by any other means possible, father has or mother has a right to record these proceedings, file it before the concerned court, and this will be taken into account as a serious misconduct of the party that can, in fact, enable the court to revoke the custody as well. Another ground that is coming up nowadays is on account of prolonged litigation. The parties start cohabiting with others, and this is taken as a ground by parents, the other spouse, to revoke the custody. Courts have come down very heavily on these practices and have said that mere cohabitation itself with a new partner will not be a ground for revocation of custody. Briefly, I'll just quickly speak about mediation. Mediation is the most effective tool in matrimonial matters. Personally, the litigation that I have conducted, I have seen parties have gained phenomenally if they have reposed their faith in mediation. Mediation is not settlement, it is not compromise only. Mediation is identifying your issues and finding quick and efficient solution to the same with the help of trained persons. It is very effective. If the mediation fails, the order sheet does not disclose the reasons of failure. It just simply discloses that the mediation has failed. So there is no liability attached to any of the parties who participate in. Mediation is available at every stage of matrimonial litigations. I would strongly urge all the parties, litigants as well as advocates, to avail this option. At the High Court level, I have seen parties have benefited enormously. Parties who would not stand together in court, who would not stand together in one room, they have been able to reach an agreement to part ways peacefully, quickly, within a span of 2 to 3 months. If you participate in mediation process, there is usually an agreement that is entered. That agreement forms a basis of your petition for divorce by mutual consent. And I personally feel that more and more people should avail mediation as it is very, very effective in litigation. Now, I'll just quickly end by answering these questions. When can I file a divorce? I can file a divorce only after expiration of 1 year of marriage. Unfortunately, Indian law as of now does not provide for filing of divorce prior to that. There is, however, exception that under exceptional circumstances, exceptional hardship, but practically speaking, it's not entertained. Litigation expenses depend upon at what stage have you sought legal counsel. If you have sought legal counsel from the very inception, your proceedings are streamlined. And with minimum proceedings, lawyers in matrimonial matters work as amicus, and they will only help you to find resolution of dispute quickly. And therefore, in those instances, the litigation cost is very less. What steps can I take before filing divorce? In the event parties have realized that the marriage is not going to last, even after 3 to 4 months of living together, you can get in touch with your lawyer. He will explain you certain things, like there's a proceeding called as 107116 CRPC. In the event either of your spouse is creating difficulty for you, with the help of family members, you can go approach police station, give a complaint, proceedings are conducted. These are safety proceedings. These are able to portray your first version and therefore there's a sound of authenticity to your arguments and your pleadings in matrimonial disputes. If you agree to mediation, does it mean I have to settle? Absolutely not. There are no winners in matrimonial litigation. The only loser is the person who does not understand importance of his time and does not relinquish the ego. Now the courts have come up with the law that the identity of the parties will not be disclosed in these litigations. And how long does it take for proceedings to conclude? It depends on, there is no fixed formula. However, if your intention is very clear, either you want to cohabit or you want to walk out, and if you are sincere, your sincerity will be seen by the court and the process will end as quickly as possible. I thank Jay a lot for giving me a chance to speak on this. And I hope people who are watching this, they get an idea as to what they are stepping into. And that's it. Thank you so much.
Well, thank you so much, Ms. Sharma, for sparing time on a Saturday afternoon. And I'm sure our viewers will be immensely benefited by this extraordinary presentation that you've prepared in such short span of time. Thank you so much once again, Ms. Sharma, for all the effort that you've put in to execute this brilliant presentation. And thank you so much, everybody, for watching our channel. Stay tuned. Next episode is on its way. And until then, please like, subscribe, and share my channel. Have a great day. Please stay home. Please stay safe. Take good care of yourselves. Thank you so much. Thank you so much, Ms. Prabuddha Sharma, once again. Thank you.